Calls the people of the state of Michigan versus David William Derider, case number 242292FY. Appearances counsel.
Joanna Carey for the people.
Robert Hartzell for Mr. Derider, who joined me to my right.
And we are here on prosecutor's objection to early discharge from probation. It's my understanding that the request for probation, early termination of probation, was filed with this court on or about September 9th. Plaintiff's prosecutor's objection was filed September 12th, and we are here today. So, Ms. Carey, this is your objection, so I'll turn it over to you.
We did get in contact with the victim, and she indicated that she would be here or wanted to make a statement. Again, I apologize because I set the file down and now I have to find my notes. But he was charged with aggravated indecent exposure and pled to indecent exposure, but there was a witness to this event and she was very upset by that. And he was found guilty of 5 technical violations in May of this year. And I will admit that those were for alcohol violations, and that was not, at least not that we know, part of the underlying offense, but it's still distressing that he wasn't. And there were five violations from December through May. And now since May he's done, I haven't been notified of any violations. However, I think that the original 24 months probation is warranted in this case, given what he was doing in the parking lot at Meyer and the violations, and the fact that the victim has at least contacted her office and wants to be involved in this. So I would ask that the court continue probation and deny the request for early discharge.
Ms. Carey, how old was your victim?
It was an adult.
All right.
I'll tell you her age.
As long as she was an adult, that's all I need to know. And
A young adult. I mean,
but over the age of majority.
yes.
All right. Is there any indication that the activity was specifically directed towards her?
I don't believe it was.
Ms. Carey, anything else?
No, thank you.
Mr. Hartel?
Yes, Your Honor. I would ask the court to consider allowing my client to get off probation. I do realize that the people have expressed their concerns. I'm not trying to take away from those concerns, but I would ask the court to factor in that since May, there has been no other allegations of violations. As the people noted, those violations did not include any allegations of activity similar to what he was placed on probation for. I would also let the court know that he has told me that I have not independently verified this, but the Merritt Township Fire Department, where he has worked in the past, has a policy where if you're on probation, you can't work there. But even with his conviction, which we realize would not automatically expunge, that would be years from now with extra paperwork, if ever. But if he's off probation, it'd be willing to let him come back as a volunteer firefighter. From what I can tell, based on my conversations with my client, he's motivated to do that. They're motivated to have him. And I'm not worried about this type of offense being an issue with that for multiple reasons, including he'll be in full uniform, surrounded by other people, things of that nature, which I lead from the front with that, just because I could see the court having questions about that. But I do believe that he is overall a good candidate for early removal from probation. He may have a statement for the court if the court was willing to listen to that, but we trust the court's discretion. Thank you.
Thank you. Ms. Bismack, were the violations in May that we dealt with, were those the only violations in this case?
Yes, Your Honor.
And did he do any type of programming at all?
Yes, he attended counseling at Lakeshore Counseling.
When did he complete that counseling?
That was completed back in September of 2024.
Then had violations, I would point out.
Yeah, I understand. His last violation, I realize we dealt with it later than this, but his last violation was May 5th. That was the last day he didn't test. Is that correct?
Correct.
All right. Anything else, Ms. Carey?
No, thank you.
Mr. Hartel?
I may very briefly, Your Honor. My client believes that I phrased everything he wanted me to phrase properly, so nothing else. No.
All right, thank you. So in deciding whether someone should be released from probation early, the court turns to MCL 771.2. In particular, it would be paragraphs in this case 3 and 6. And essentially it allows for the early termination of probation at the halfway mark or a later date, as long as the defendant has not had any violations for at least 90 days. Then I turn to paragraph 6, and it states, in situations such as this, that the court is asked to determine whether or not probation should be terminated early, and the court decides that it should not be discharged early. The court must state on the record a specific rehabilitation goal that has not been met or achieved, or a specific articulable and ongoing risk of harm to a victim. In this case, while I understand completely Ms. Carey's concerns, there was no indication that the victim in this case was a targeted victim. So I don't believe there's an ongoing risk or a specific risk to that specific victim. I also, it sounds as if the rehabilitation goals have been met. He's done what he needed to do as far as probation. While I realize that there has been violations in this case, it was for failing to test. There's no indication that the court has, although I will admit I was not the judge on this case at the time of the plea and the sentence. I suspect, given that that was an order, there was probably some sort of concern for that. But again, it's been over 90 days since he was violated on that. And without anything further, I believe the court's hands are tied and that I have to grant the request. So, Mr. Derider, I hereby grant the request to terminate your probation early. Sure. Anything else, Ms. Carey?
No, thank you.
Mr. Hartel?
No, thank you.
All right, we are adjourned.
Okay with you.
All right, court calls the people of the state of Michigan versus Tristan Hornbeck, case number 253661 SM. Appearances, counsel.
Courtney Lawrence on behalf of the people.
David O'Meara on behalf of Mr. Hornbeck.
And we're here for, it looks like a plea and sentence. Is that correct?
It is, Your Honor. It's my understanding the defendant will be guilty as charged with an agreement for HYTA.
Ms. O'Meara?
That's my understanding as well.
Here. I guess what's throwing me off is I have an appearance from Mr. Hartel, an appearance for Ms. Fiorvento, but no substitution of counsel. Are you both of counsel or of record, I mean?
Yes, Your Honor, Ms. Fiovento had some scheduling issues and I filed an appearance so I could be here for this portion of it. I don't know if the courts want to allow that or not. We were both working with Ms. Enjamera as a team. I don't know if that's acceptable.
Mr. And looks like that happened, yes.
I knew it was the recent past.
Looks like October 6th that was filed. Mr. Hornbeck, Ms. O'Mara is probably who you've been dealing with. Ms. Fiorvento is the actual supervising attorney. She is not here today. Mr. Hartel has filed an appearance to appear on this case as well. This is entirely up to you as to whether or not you want to proceed today without the supervising attorney who was originally assigned to your case and looks like throughout the entirety of the case until Monday. Do you wish to proceed?
Yes.
Yes? All right. Do you need a moment to talk to anybody about that?
No.
No? All right. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
It's my understanding that you will be pleading guilty as charged to the offense of retail fraud, third degree, which is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 or 3 times the value of the difference in the property taken. Additionally, there is a plea sentencing agreement that says that you would be sentenced pursuant to HYTA, which is the Holmes Youthful Trainee Act. And if you're successful with that probationary period, then the case would be dismissed or at least removed from your public record. Do you understand that?
Yes.
Now, that's an agreement that you have with the prosecutor's office, and that's not an agreement you have with me. So if I decide that I'm not going to follow that agreement and put you on HYTA status, you would be able to withdraw your plea. Do you understand that? Yes?
Yes.
All right. Do you have any questions for me about the plea process at all? Or what HYTA means?
No.
All right. Back on August 7th of this year, were you on probation or parole?
No.
Were you on bond?
No.
Do you remember reading and signing this advice of rights form, talk about your rights to an attorney and your rights to a trial? Ms. O'Mara? Do you remember reading and signing that?
Yes.
Did you understand those rights?
I don't remember any of it now, but
Okay, so I'm going to go through it with you, all right? Because I want to make sure that you're aware of your rights. So if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You've been brought to court on a misdemeanor charge. You have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. To have a trial by jury and to the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and if the offense charged requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. You have the right to a trial, and you have the following basic rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court. To see, hear, and question all witnesses against you at trial. To be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up the rights that we just went through. You have the right to be released on bond. If you are now on probation or parole and you enter a guilty plea or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence or is permitted pursuant to court rule. If the sentence includes incarceration and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and/or state law may prohibit you from purchasing or possessing ammunition or a firearm, including rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights as I've read them?
Yes.
Do you have any questions for me about those rights?
No.
Most importantly, do you understand that you have the right to a trial by jury, and if you enter a guilty plea, you'll be waiving that right and you won't have a trial of any kind?
Yes.
Knowing all that, then, do you still wish to proceed with the plea?
Yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then Mr. Hornbeck, to the allegation that on or about August 7th, 2025 in Herring Township of Wexford County, how do you plead to retail fraud third degree?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on August 7th, were you at the Walmart store in Herring Township?
Yes.
And while at that store, did you attempt to take or actually take property from the store?
Yes.
And did that property have a value of less than $200?
Yes.
Did you actually get out of the store with it?
No.
Had you passed all points of sale?
Was that-
You passed all the cash registers?
Yes.
And was it your intent to at least try to take the property?
Yes.
And how old were you at the time of the offense?
18.
18. All right. Do counsel believe the defendants provided a factual basis in which to accept the plea and that the court rule has been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. I am going to take the plea under advisement because it sounds like we have an agreement for HYTA, so I'm not going to enter the guilty plea yet. Are we able to sentence today, Ms. Lawrence?
Yes, Your Honor.
Is there any restitution requested?
No.
Ms. O'Mara, allocution?
Thank you, Your Honor. Mr. Hornbeck is currently working towards the GED. He's taking steps towards that. He's starting a new job on Monday at FIAMM
PM?
which you, I guess, are aware of.
They make auto horns.
Yeah, the car ones. I asked if it was loud in there. It said, no, it's not. So, he lives with his mom here in Cadillac. This would be his first conviction of any sort. He relayed to me that he feels stupid for the thing, or for his actions in this instance, and that obviously he made a mistake and was embarrassed. I think that this is the type of offender that HYTA was created for, and I'd ask you to follow that agreement. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. Just from reading the report, it seems like this was maybe a group of buddies. Because I came up with this idea together to steal some stuff from Walmart. I think maybe this is one of the situations at that age you surround yourself with. I agree with the defense. I think this is a good defendant for HYTA. He's very young, doesn't have a history. It does seem like he was very cooperative with the asset protection officer from Walmart. So I would ask the court to follow.
What was at least attempted to be taken?
A strip, jogger sweatpants, a Roku remote. Yeah, I believe that.
And you said there is no restitution.
Your Honor.
Mr. Hornbeck, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
No.
Is it, as Ms. Lawrence made it sound, that this was just a group of
Yes.
kids decide they're gonna try to lift stuff from Walmart?
Yeah.
Well, Mr. Hornbeck, HYTA is designed for young people. That's why people my age don't get it. The law realizes that young people do stupid things. And this is one of those stupid things. I hope this was a first time for you. I hope we just didn't catch you as we do some people after multiple attempts, but your age also qualifies you for the HYTA trainee status. So I am going to follow the agreement and put you on a period of probation for HYTA. Now, I'm sure Ms. O'Mara has talked to you about this, and I mentioned it briefly, but as long as you are successful with the probation that I'm going to put you on, this charge is going to be removed from your public record. Law enforcement is still going to be able to see it. The courts are still going to be able to see it, but any member of the public running your record, jobs, housing, sometimes credit reports or, creditors, they're not going to see this as long as you're successful with it. Now, if you're not successful with it, the charge is going to enter. It's going to be on your public record, and it's going to show that you've got essentially a shoplifting charge. Also, if you're not successful with it, I could sentence you to what I could have sentenced you to with what you pled to, so up to 93 days in jail. Not saying I would do that, but that's certainly the outcome here. So there's a lot riding on this. While I realized that you were young when it happened, employers and landlords might not necessarily see it that way. Especially when it comes to an employer, they're going to look at, do I hire a thief or not? So that's why it's so important that you follow through with this. So let me ask you, are you 18 now or are you 19 now?
I am still 18.
You're 18. Have you finished school?
No, I dropped out in 11th grade.
In 11th grade?
Yes.
And how long have you been at FEM?
I have not started working, but I start working on Monday.
Monday, okay. All right. Have you had any jobs between school and now?
I've had little under the table side jobs with family, but other than that, no.
Okay. All right. Are you hired in at FEM or is it going to be on a temporary?
It's hired.
You're hired
I
in,
start on Monday.
but it's through FEM itself, not an employment agency.
Yeah, it's through FEOM itself.
Mr. Hornbeck, I'm going to put you on a very short period of probation for a couple of different reasons. One is you're not eligible for early release. If this were normal probation, when you're at the halfway mark, you'd be able to be released from probation. Because this is HYTA, that doesn't apply. You'd have to finish the full HYTA sentence. The other thing is you're just getting started. You're just starting a new job. And I don't want probation to, I'll say it, I don't want probation to hold you back. I don't want probation to interfere with any job requirements that you have or anything like that. But I also want it to be enough of an attention grabber that this doesn't happen again. So I'm going to put you on a period of probation for 3 months. All right. During that 3 months, you are not to violate any law, report as ordered, not leave the state without the consent of your probation officer. Keep your contact and employment information current. You are not, as I said, eligible for early release. I'm going to order that you attend a retail fraud program. I'm either going to order that you be employed, and if you're not employed, let me ask you, you said you dropped out of school. What kind of student were you?
What do you mean?
Were you a passing student? Did you struggle a little bit?
I was struggling a little bit, but then I moved up here and Tennessee credits are way lower than Michigan, so I couldn't enroll into school here.
You came from Tennessee.
Yes, sir. Correct.
So I either want you employed or I want you working towards your GED. All right. I'm not gonna make you do both because I don't want to burden you down. And I realize you're not gonna be able to complete your GED during the time of period that you're on probation if you have to. But I want that to at least be started if you lose your employment. Does that make sense?
Yes.
There will be a $75 Crime Victims' Rights Funds fee, $50 state minimum fee, $150 fine. I'm going to waive the court costs, attorney fees.
We'll waive those two.
Attorney fees are waived, $0 in restitution. The 3 months of probation is going to be $90. All right. And I am keeping jail open. So as long as you do what you need to do, there's not going to be a jail sentence. And as I said, the pleas being taken under advisement, which I realize is a legal phrase, but what that means is I am not finding you guilty yet. The only way I'm going to find you guilty is if you violate probation and then I terminate the HYTA status, then I find you guilty. Does that make sense?
Yes.
All right. Do you have any questions for me about your sentence?
No, I do not.
All right. Any balance that remains unpaid for more than 56 days by operation of law has a 20% penalty added to that. Does that make sense? So I ordered fines and costs. You have 56 days to pay those. If you don't, a 20% penalty gets added to that.
Okay.
All right. All right. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan. And then you'll need to go downstairs to the probation department and get signed up for probation. All right.
Okay.
All right. Good luck.